motion to vacate the trial court's order, which was, I think, April 24th.
Let's see the order. I have a copy of the order.
I have a copy, I think.
That was an order that actually was entered, I guess, ex parte, correct?
It was ordered without hearing.
Right, that's what I mean. It was ordered in chambers based on the motion without affording the defense an opportunity to argue good cause, correct?
Correct, but and that was April 25th is the date.
Okay. So assuming, does the state have a position on that one way or the other?
The state would ask that the motion be denied, but if Your Honor is inclined to strike the state's notice, I would ask that Your Honor find in open court, after giving the defendant an opportunity to be heard, that there is good cause, and then allowing us 15 business days to file a second amended notice stating our aggregated factors as required by the law, the amended law 782.041B.
All right, so Ms. Burke, assuming the court were going to vacate the last order,
Yes, Judge.
what is the defense position on why there is not good cause?
The reason there isn't good cause in the motion that was filed in this case is there are 6 points alleged in the motion for the court, and the third misstates the holding in Hearst and asserts that that's the basis for the cause, and that misstatement, therefore, it fails because if that's actually not the holding in Hearst and it's not why we are here, then that can't be the basis for the cause.
All right. Any other position as to why the state did not have good cause to...
And there isn't something pled that would be a basis for good cause. Is it possible for them to establish cause in these cases where the pre-45-day death penalty case? I think it is possible. Has it happened in this case? No, it hasn't, based on what was asserted in the motion that was filed by the state on April 20th.
Well, the good cause, Judge, that the statute was not in effect. And when the statute became in effect, we had then 45 days to file an amended notice and seek leave. We did so on April 20th, which was our 44th day. The good cause is that we can't adhere to a statute that wasn't in existence.
So the statute was enacted, and within the 45 days, the state saw leave to...
Yes, the new sentencing scheme came into effect statutorily on March 7, 2016, to the 45th day, which is April 21st, 2016. We filed our amended notice and motion to seek leave on April 20th, so 44th day.
So what, again, let me just seek from the defense. Obviously, the state is attempting to comply with a new statute that wasn't in existence at the time. So how are you prejudiced by them?
There isn't a prejudice by them seeking good cause. There would be prejudice by saying that they've established it without giving us an opportunity to be heard. If what Mr. Scott just argued has been alleged in the motion, I think it would be possible for them to have established good cause.
Well, isn't that sort of what they're saying by citing her? I mean, essentially invalidated Florida's death penalty.
In terms of the requirement on aggravating factors, that's actually the legislature, that's not Hearst. Hearst actually has to do with what the maximum punishment is and what the jury findings are of those essential elements.
Oh. All right, anything else with regard to that issue?
Nothing to say.
Ms. Burke?
No, Judge.
Okay. So let's deal with your other issue.
Okay, so is Your Honor granting the motion to vacate?
Assume the court is going to grant the motion, vacate the prior order, find that, actually I could vacate the prior order, find that there is good cause for which the state can file.
Okay. And now we have additionally filed a motion to strike the state's amended notice. It sounds like Mr. Scott is asking for an opportunity to file an additional amended notice?
Well, if Your Honor is going to strike the state's amended notice and give us 15 days or 10 days to file proper notice, if that's Your Honor's ruling, then we're going to do so within Your Honor's time frame.
So how much time? 10 days?
10 days is fine.
10 days is fine. Okay.
Okay.
So assuming we're going forward and the state's filing, is there going to be any difference in the notice?
I would say probably not, but I just want to consult with Ms. Skiles and then file the appropriate pleading.
All right, and then your other motion is?
The other motion is regarding the motion to strike the state's amended notice. If there's going to be a different one, I don't know if it's premature to argue it now.
Right.
Because it failed not only, there was the issue around the 45 days and whether or not leave of court was sought, but additionally, the indictment failed to charge the aggravators.
Right. And
based on the line of cases, starting with Jones and then moving to Apprendi, Ring, Aline, Hurst, it's our position that because the indictment fails to do anything other than charge first-degree murder for purposes of satisfying this capital sentencing scheme requirement, we do know that there are other counts charged, but it doesn't actually satisfy the requirement that the notice would have to be struck for that reason if it's going to be the same.
State positions, there's no statutory or case law authority that states we have to list our aggravators in the charging document. We simply, the Apprendi case law and litany, that goes up through Hearst doesn't address that. Apprendi and Aline and the litany are dealing with essentially crimes in which there would have to be facts alleged in the indictment or the information because it would increase the maximum possible sentence. In this first-degree murder, the possible penalties have always been life or death as stated in the statute. There's no increase. Those are what the punishments are. And there's no authority that says we have to state the aggravators in the indictment. Moreover, because now we have to state our aggravators within 45 days of filing the indictment, the defense is on notice of the aggravators we intend to prove. There is absolutely no prejudice to the defense whatsoever. So it's the state's position that we have complied with the statutes and we have complied with the case law with respect to both our indictment and our notice requirement under the new sentencing scheme.
Yeah, so what is your position as to the notice? Why doesn't the statutory notice satisfy?
The statutory notice doesn't satisfy. It's just to correct a few things here.
Well, but I mean, the state has to file a notice of intent to seek, correct?
Correct.
And they have to list the basis, right?
Correct.
They list the aggravating factors they intend to rely on. Why doesn't that satisfy, why wouldn't that satisfy your argument?
It doesn't satisfy, well, there are a couple of things. First is that the state is saying that the maximum punishment for first-degree murder, the presumptive maximum punishment for first-degree murder in the state of Florida is life without the possibility of parole. That's clearly stated in Hearst and a series of other cases. Additional steps have to be taken and additional facts have to be proven for the state to be able to receive and seek constitutionally the death penalty.
Isn't that what the notice requirement does?
Not satisfactorily. It doesn't satisfy the constitutional requirements because under Jones, it says to satisfy due process as well as Sixth Amendment requirements that an increase in maximum penalty for a crime must be charged in an indictment, submitted to a jury, and proven beyond a reasonable doubt. So that, whatever the state is going to use as a factual basis for the increase, and that would be all the aggravators, those need to be pled specifically and explicitly in the indictment. So the indictment under the Sixth Amendment and due process.
So assuming the state were to say, okay, we're going to, we review this case, we're going to take it to a grand jury, we believe this is a death penalty case. We believe, A, B, C, and D aggravating factors are present, we're going to put that in an indictment. Suppose they do that. Would they still have to do the notice requirement?
I believe so. That's what the legislature said.
Well, what would they be noticing?
That's what the legislature said.
Well, what would they be noticing you of?
I think the notice is actually about more than one thing, and I think under the sort of due process death penalty cases, starting with Woodson versus North Carolina through Dan, sort of talking about the reverse pyramid or the cone, we're talking about testing various facts and elements so that it narrows who is ultimately going to be able to face the death penalty, and each of those things should satisfy a level of review. It's not merely notice. It actually is also supposed to narrow the class of people who could potentially face the death penalty.
Judge, the purpose of the phase two part of the sentencing and of the requirement that we list the aggravating factors in a notice, and that's the whole purpose, is to put the defense on notice of this class of person, this defendant who will be receiving the death penalty.
Right. I mean, these are the aggravating factors we intend to rely on to seek the death penalty. We're giving you advance notice, so, presumably there's no surprises, and we're not going to, the day before trial start coming up with new evidence. You know up front what factors the state intends to rely on.
However, there are also proof standards that are part of that requirement that have been now promulgated by the legislature. They're saying that within 45 days, it's the aggravators that the state has sort of good faith basis to believe it can and will prove beyond a reasonable doubt.
Correct.
This, again, serves to narrow. But that needs to begin in the process with the grand jury because these are elements. And that's really what Hearst stands for, is that what basically Florida was calling sentencing factors and sort of trying to reduce, and Justice Ginsburg and Ring, as well as Justice Sotomayor and Hearst, both made clear it doesn't matter what the state chooses to call it. It is an element. A lien solidifies that it's an element. And if it's an element under Jones, it has to begin in the indictment, in where and how it appears.
All right, so just as they allege, or it did from a premeditated design that did affect it or whatever,
Right.
you believe they need to list the aggravating factors also as an element.
They need to indict on the aggravating factors as elements. Yes, Judge.
And has the state given any thought to that? I mean, in terms of, let's cut out all these motions, let's just put them in the indictment, or is that...
Judge, these aren't elements of the crime. There's no requirement, statutorily, case law, or otherwise, that says that we, the state, have to allege our aggravating factors in the indictment. It's just there's no requirement. You're imposing additional requirements on the state that are not there. These are not elements. They are strictly for a phase two sentencing scheme as is outlined in the new statutory requirements that we file a notice and that we proceed to tell the defense, put the defense on notice as required by due process. These are the aggravating factors that we intend to prove in phase two.
Not only are they elements, but they've been elements as established by the U.S. Supreme Court. And Florida has had an illegal and unconstitutional death penalty scheme since Ring was decided. So Florida has been prosecuting capital defendants unconstitutionally for 14 years. And it's wrong again. And it failed in terms of a constitutional analysis under Sixth Amendment due process.
So let me just ask the defense, so I'm clear. Assuming the state's going to obviously file a new notice.
Yes, sir.
I've heard your argument today. I've heard the state's argument. They're going to file a new notice within 10 days. Is this a motion we need to actually rehear, or?
I'm not...
I mean, you're challenging the notice in any event, right?
Yes, sir.
You're saying the notice doesn't cure the
Correct.
problem. It needs to be, these things need to be alleged in the indictment.
Correct. If the notice only comes as the notice that we've already received and there's no indictment changes, yes, our position...
Can I see the notice? Do you have a copy? Thank you.
I do,
The amendment notice to seek with the aggravating factors I do is marked up.
Yeah, I just want to see what was alleged without the markings. All right, so in this case, the state filed an amended notice, and it said that they intend to prove the unreasonable doubt the following aggravators pursuant to Florida Statute 921, 141, 1. Defendant was previously convicted of another capital felony or of a felony involving the use of threat of violence to the person. The capital felony was committed while the defendant was engaged in committing or attempting to commit any robbery, sexual battery, aggravated child abuse of an elderly person, disabled adult, resulting in great bodily harm permit, disability permit, disfigurement, arson, burglary, kidnapping. Perhaps the state may want to narrow that one a little, but that's up to the state. 3, the capital felony was especially heinous, atrocious, or cruel. 4, the capital felony was a homicide, was committed in cold, calculated, premeditated manner. 5, the victim of the capital felony was was less than 12 years of age. And 6, the victim of the capital felony was particularly vulnerable due to advanced age or disability, or because the defendant stood in a position of familial or custodial authority. So assuming, with respect to number 2, let's say the state narrows that a little bit. How does that not put you on notice as to what the state is seeking to prove?
It isn't just the function of it. It's our position that the function of it isn't merely to notice us. It's actually to review and evaluate at every stage.
Well, I mean, Florida statute says that's what the state's supposed to do. Notice, put you on notice of what aggravating factors they believe warrant the death penalty or what they're going to prove.
Well, it's because, and again, there's a proof standard. The U.S. Supreme Court leaves us with these as elements, which means they need to appear in the indictment. But additionally, the Florida legislature gives us a proof standard for these. And part of what's required is that there be some consideration and narrowing, including, so I certainly wouldn't be waiving challenges in terms of what these 6 things allege and claim regarding all kinds of other constitutional infirmities in terms of doubling, as you have noted in terms of number 2, that there's, I mean, additionally, they're citing the wrong statute number. It's actually 6B and 6B, not 5. That's the old one. So things are vague and overbroad and not sufficiently specified, and they repeat. And again, I'm not limiting our challenges to that, but that's where they begin.
All right. Well, I think what I'll do today, at least for purposes of motion 1, I am going to vacate the prior order. Just for the record, that was dated
April 20th, I believe.
Your order is 25th, Judge.
25th, okay. So that order will be vacated. The court has now heard a defense position as to good cause.
Yes, Judge.
So I am going to deny your motion. I grant the state's motion to file an amendment with 10 days.
10 days to state, Judge?
Sure. And I'm assuming, really, I might as well reserve on any other issue because you're going to be back.
We will be back.
Yes.
Yes.
So once you receive, it'll now be a second amended notice. Once you receive that, we'll probably be back.
Sure.
And we're set for trial in this case when?
January 28th, I believe. And Your Honor did issue a scheduling order. We do actually have a status set in August that I don't know that we need, given that we do have a scheduling order.
Well, if you want to keep that status, and then we could deal with regarding your motion at that point, you want to do that?
If we can, we can keep that as a hearing date.
What's the court show January when? I'm sorry, August what?
August 29th at 8:30 for a statutory.
That's a Monday, Catholic?
So do you want to just keep that date, and then if, assuming the state's going to file a response,
August 29th is a Monday.
Thank you.
so the state's going to file an amendment within 10 business days, you can renotice your motion, and then just renotice it to the 29th, or leave that for that.
Okay.
Okay? All right, anything else?
No, Judge.
No, Judge.
All right, thank you all very much.
Thank you.
Good luck for recess. Okay, is there a reason to go?